My name's Joe Frick, and today we're going to talk about what physical custody is in Idaho. And before we jump into the topic, it is important to understand that there's a distinction between legal custody and physical custody. Legal custody pretty much boils down to who gets to make the decisions for the kids' lives for important issues such as religion, healthcare, or education. Most of the time, people get joint legal custody, so both parents have the ability to make those decisions for their child. If they can't make those decisions by agreement between the parties, they have to go to court, and the court will make a decision for them. Now, legal custody, that's what that is. We're talking about physical custody today, which is essentially who gets the kids and where they're actually be living, and who's going to be responsible for their day-to-day care. Physical custody also sometimes determines the primary residence of the child. In some situations, one party should be deemed the primary residence for the children so they know which school they're going to enroll in and so forth. If the parents are kind of in the same vicinity and they're sharing 50-50 custody, sometimes there's not a need to determine who is going to be the primary residence of the children. Now that we know what physical custody actually is, it's important to know where to actually file the case, because physical custody and jurisdiction are very important issues, because if you file in the wrong place, then your case is either going to get dismissed or you're going to have to file again somewhere else. Now, where you're going to file the case is going to be governed by the Uniform Child Custody Jurisdiction and Enforcement Act. Now, it's a big mouthful, but that's the UCCJEA, which pretty much most family lawyers know by heart. But essentially, that is going to determine where you have to file your case and which state you have to file your case. Now, pursuant to the UCCJEA, you have to file the case where the child's home state is. And how they determine that is pretty much where that kid has lived in the past 6 months. So if that's Idaho, it's Idaho. If the kid lived in Washington for the past 8 months and you guys just moved over here for 2 months, that has not established that the Idaho is the home state. Washington would still be the home state because the past 6 months, that's where the child resided primarily. Now, that doesn't mean you can't file the case in Idaho. There are certain exceptions to the rule where it's the most convenient forum. All the evidence related to the kid and their lives is in Idaho now versus Washington. So when you're making that decision, you got to make sure if you haven't been living in Idaho over the past 6 months, you just moved here, or the kid just moved out of state for a month or two, you need to talk with a lawyer to figure out what actual state you're supposed to be filing that case in, because you could be filing it in the wrong state, which could cause you more legal fees, which would kind of just a domino effect of the fees, timing, emergency issues, all that stuff's going to get kind of tied up until you get the case filed in the right state. Now, if you're filing in Idaho, you still have to figure out where you're going to file the case, which county you're going to file the case in Idaho. And in Idaho, typically it's going to be wherever the other parent resides. So if you live in Ada County, other parent lives in Canyon County, and you're the one filing the case first, you're going to be filing the case in Canyon County, even though you live in Ada County, because that's what the rules say. Now, later on, if you want to modify the custody order, there's a little bit different story, because you have to file essentially in the case that the decision was made. So if the decision was made in Canyon County, you have to file initially in Canyon County. Now, if both parties move to Valley County, let's say, after that, you're still going to have to file in Canyon County, then get the case moved to Valley County to be in the correct jurisdiction. It's very complicated. Talk to an attorney. They can figure it out for you. But when you're deciding on who or where you're going to file the case, you're going to want to figure that out so you don't waste time and money. When we're talking about physical custody, we also have to make a decision and talk about the distinction between sole legal custody and joint physical custody. In Idaho, there is a presumption that joint physical custody is in the best interest of the child. But joint physical custody pretty much means that each party is going to have some sort of visitation rights to make sure that they have, an interaction and a relationship with the children. That doesn't mean that it's going to be a 50-50. Joint custody pretty much just means that each parent has sufficient, substantial time with their kids to, have that relationship. It could be every other weekend. That is still considered joint physical custody. Sole physical custody is the exception and not the rule. Sole physical custody is granted rarely. There has to be some very significant issues with the other parent for the other parent to get sole legal custody, such as severe mental health issues, the other parent's incarcerated, the other parent lives several states away and hasn't seen the kid in 5 years. There's a lot of different factors that could add up to one parent getting sole legal custody. But when we're talking about that, you have to kind of analyze the situation as a complete whole. What's everything going on in the kids and the parents' lives to figure out who should have the kid and when, whether that's sole or joint. When the court's making a decision on joint or sole custody, physical custody, also on what percentage of overnights the other parent should have or each parent should have, they're going to be looking at the best interest of children, which is a totality of the circumstances analysis. So just keep that in mind and go through everything that's going on in your kid's life to figure out, who's going to be getting joint physical custody or sole physical custody, and if it's joint physical custody, who's going to get the percentage of overnights, whether it's 50-50 every other weekend. That's what the court's going to look at. So when the court's making that best interest determination, the court relies on a statute. They kind of list several factors that the court's going to look at every time and kind of pick and point. Maybe that's where they make their findings of fact. They look at everything, they look at these factors, and they make a decision on who should have the kids and when. Now, there's several statutory factors that the court looks at, but that does not mean that they're not going to look at stuff that's outside of that list. It's not an exclusive list. You can look at other stuff that's not on the list. But I'm just going to go ahead and read off most of them because it's kind of a long list. So when the court's making a decision on who should have physical custody of the kids, they're going to look at those several factors. One of them is going to be what the kids want, the wishes of the children. One of them is going to be the wishes of the parents. One of them is going to be the child relationship with each parent, along with other people that's involved in the parent's life, such as cousins, grandparents, teachers, stuff like that. They're going to look at the stability of each parent's home. They're going to look at the character and circumstances of all the parties involved. And this is the factor that you can kind of dump a bunch of miscellaneous factors into it, because the character and circumstances of the parties involved is pretty much a very vague, wide open factor that the court will look at. Now that includes, the parent's ability or inability to get the kids on school on time, one parent's inability or refusal to comply with doctor's recommendations, whether they have substance abuse issues in the past or recently, same with criminal charges. There's just a very long list of items that could be shoved under the character and circumstances factor that would be relevant to the case that is not specifically listed in the statutory list of factors that the court will look at. One of the other issues that the court's going to look at is whether domestic violence has been involved by either party. And they're also going to look at whether that domestic violence happened in front of the kids or outside of the presence of the kids. Generally, if it's not in presence of the kids or doesn't involve the kids, it's still going to be a very serious issue that person that committed the domestic violence is going to have to overcome. But that doesn't mean that automatically, because they committed domestic violence, they're not going to get any custody of their kids. Another issue that comes up a lot when we're talking about physical custody is when one parent wants to move the children outside the state of Idaho. Now, when they make that request, whether that's you or the other parent, you have to understand that's a very high burden and you have an uphill battle when you're trying to move the kids out of state. That's because in the state of Idaho, Supreme Court is very clear that when they're looking at the decision on letting one parent take the kids out of state, they look at it through the lens of, is the move in and of itself in the best interest of children? Now, when they're looking at that, they also look at, other factors related to the move. When they're looking at that, they'll look at the impact of the child's relationship between the parents. If they did move, so if they moved to Texas, it would be very difficult for the other parent to exercise their 50-50 custody rights. Now, if the non-moving parent, the one that's staying in Idaho, only has every other weekend or some time in the summer, that's going to be a less relevant factor because they don't see the kid that much anyway. Another factor they will look at is the reason for the move. Now, if you have an extremely great job opportunity in Nebraska or Kansas, and that's the reason why you want to move, and your income is going to substantially increase, which would allow you to put the kids on private school, you'd allow them to get better health care. You have to stack on those reasons why you think the move itself is in the best interest of children if you want to be successful in moving the kids out of state. Now, the court's decision or the parent's agreement on what the custody order is going to be is going to have a very big impact on who pays child support and how much. I will address the child support issue in a different video, but the basics of it is essentially they take both parents' income and they combined it to become a basic child support amount. So that's just the amount that it's going to cost to raise the kid relative to the parent's income. Now, after they take that total combined amount, then they look at what percentage of overnights each parent has, and they make a calculation from there. There's a lot of other factors that are involved, such as, who's paying the health insurance premiums, who's paying work-related child care expenses, and several other issues. But the main factors are the combined income, the total amount of combined income, and the percentage of overnights that each parent has.